Hello and welcome back. Thank you so much to the United Nations Conference on Space Law and Policy. I really appreciate everybody taking the time to join in and everything. We have some really earlier discussions, very interesting and enlightening on so many different aspects. And now I would like to just mention one thing. I've noticed in the chat, we've seen a number of questions. We'll go ahead and post all of the presentations when the conference is finished. I will also post the recordings and everything, so that will all be done a little bit later on this week. And without further ado, I'd like to move on to our next presenter. We're really lucky to have our good friend Gabe Sweeney from the Department of Commerce, has had an illustrious career, and as I'd mentioned before, was one of the architects of the Artemis Accords. Gabe, the Artemis Accords have already come up in numerous ways. It all precedes you. I'm sure your ears are burning. Earlier this morning here, and you're from the United States, I really want to thank you so much again for taking the time. Please let me know, would you like me to screen your slides from my end? Thank you so much again.
Yeah, that'd be great if you want to screen the slides.
Okay.
And I'm going to assume you're able to hear me too. Oh, now I can't hear you.
Here we go. Thank you so much. Sorry, I hope you heard a little bit of an introduction there for you. Really, it's such a pleasure. And like I said, architect of the Artemis Accords, now in the Department of Commerce, looking for maybe regulation of all those private sector industries. Maybe you can give us a little flavor of what's in our future for space exploration. Did you want me to share your slides from my end?
If you can, that'd be great. Can you hear
I
me?
will do so. Thank you so much.
Okay. So I'll get started while we're getting the slides up. So yeah, good morning, good afternoon, good evening, whatever time it is for everybody who's participating. And huge thanks for the organizers, and in particular for Michael Newman for organizing this. The lineup you all have for this is absolutely fascinating. And I did want to acknowledge at the beginning that I'm going to be talking about Article 2, and I know that Stephen Freeland is going to be talking about Article 2 a little bit later in the program, and I think that's absolutely perfect. A perfect lineup. Hopefully I can set the stage, and then Stephen can talk a little bit about what the bounds are, because I am looking forward to hearing what he has to say about that myself. I think this will be a good two-parter for you on Article 2. So yeah, the subject of this discussion is occupation and use of the moon and other celestial bodies. What does the future hold for space exploration? And I should say that I'm just going to lump celestial bodies in together throughout this conversation. Sometimes I'll say the moon, probably. Sometimes I'll say celestial bodies. If anyone sees a distinction in terms of law or policy or practice, I'd love to hear about it, actually. But in terms of the way I'm doing the thinking, celestial bodies all essentially, at least for the questions I'm looking at, can be treated the same. So that's just one quick note. Let's go to the next slide. So as Michael said, I am at the Office of Space Commerce in the U.S. Department of Commerce, and I did want to give you all an opportunity to hear a tiny bit about OSC, because we're one of the almost certainly the smallest space-related office within the U.S. government, although we are growing. And I should say I've only been there for about three weeks, so I'm also still learning about all the cool things that are coming out of the Department of Commerce. Technically, Office of Space Commerce sits within NOAA, which is our National Oceanographic and Atmospheric Administration. I'm sure many of you all know that NOAA is sort of the premier Earth observation agency within the U.S. government, along with NASA, I should say. They also do a whole range of things relating to fisheries and atmospheric science. And because of the history of Earth observation and Earth observation satellites, the Office of Space Commerce was established initially to deal with issues related to remote sensing. Although, as I'll talk about here in a second, our mandate has and is expanding. It's continued to expand over the years. So we have three missions, really. Regulating remote sensing. We're the regulator for U.S. remote sensing companies. So that was sort of the one of the initial impetuses for creating the Office of Space Commerce. As Michael hinted, there's currently movement within the U.S. system, the political and legal system, to, let's say, reform or enhance the way the United States regulates and governs commercial space activities. As many of you all know, the US regulatory system is a number of decades old and doesn't have a clear home for some of the new activities that are happening in space, particularly with the private sector doing things that we haven't seen ever before. So there's a need to update that system, and a few proposals floating around. One was just released by the White House and the interagency, including the Department of Commerce, a few days ago. And there's other proposals in our Congress. And one thing all of those proposals share is a desire for the Office of Space Commerce to regulate an increasing number of space activities. So we'll see what happens, but that is certainly on the path. I'm happy to talk about that as best I can if people have questions, although much depends at this point on Congress. So I can't predict that future. So that's our regulatory role. We also have been tasked under the previous administration and continued through Congress and under this administration with taking over space situational awareness in terms of the public-facing role from the U.S. Department of Defense. So we are in the middle of shifting responsibility for providing just vast quantities of space situational awareness data that's currently obtained through U.S. government radars and other means. Making it available to the public. That's been done by the U.S. Department of Defense for a number of years, and we're transitioning that to a civil program. That's going to be called TRACS, TRACSS, as you can see on there. And it's just an enormous undertaking. I'm sure you all can imagine the quantity of data that is generated sort of on a real-time basis, tracking everything that's in orbit, and then sharing that with users with a level of fidelity and detail that they need to know to avoid conjunctions and continue safe operations in space. So that's a huge undertaking as well. And then finally, the third thing that we do at OSC, which is really where I come in, is we also do advocacy, policy, and international engagement relating to space, all in support of the U.S. commercial space sector. So this is things like listening to companies and understanding what would benefit them, either domestically inside our own system or externally with international actors, helping develop policy to do that. And then, of course, engaging with you all, with the entire international community, civil and commercial in particular, sort of the entire suite of international engagement to help out our space sector grow. So, that is an increasing slice of the space pie. So our mission in that area continues to grow. And I'm the director of the division that does those last highlighted things. So that's where I'm coming from. And I should say it's probably fair to acknowledge that, where you stand depends on where you sit, as they say. And I do sit in the Department of Commerce. So I think you'll see a bit of a commercial flavor, perhaps more than you've heard from me in my previous roles. I was previously at NASA and then before that at the Department of State. So let's go to the next slide. Okay, just a quick note on words. The title of this presentation involves the word occupation. And, I've seen online on what formerly used to be called Twitter and elsewhere, a little bit of concern about this term. I should say the title of the presentation was created before I even came on board. So I didn't have anything to do with that, but I don't think it matters a lot because I just want to sort of set out how I'm interpreting the term occupation for purposes of this discussion. That word, for example, has its own meaning within international humanitarian law and the laws of armed conflict under the Fourth Geneva Convention, for example, and it just has a lot of sort of intellectual and emotional, rhetorical and philosophical baggage with it. When I'm interpreting occupation in the context of this discussion, I mean something very basic, just being there. If you're occupying the moon or a celestial body, I just mean you're there, you have a presence, and you're engaging in some sort of activities. And I think this comes up because we're starting to see, certainly planned and in the very near future, longer term missions than we've ever seen before. So it's only occupation in the most basic sense, the sense of being in a place, doing stuff. So that's all I mean when I say occupation, and that's how I interpret the title of this presentation. So I hope we can avoid getting distracted by other possible meanings of occupation, because that is not what we're talking about. At least that's not what I'm talking about here. Next slide. Okay, so I do have a thesis for my presentation, and hopefully I can support that as I go along. But I wanted to go ahead and give you the blue for bluff, which is a term I've stolen from our national security folks. That stands for bottom line up front, if you haven't seen this before. So the bottom line up front for my presentation, and we'll see if I can support this, is that we actually know more than we think we know, particularly when it comes to the legal regime that surrounds Article 2 and some of the issues I'm going to be talking about. There's been a huge amount of intellectual swirl and conversation about these issues, particularly since 2015. And that's all obviously appropriate. I think it's been really productive. And I actually think that, a number of years in now, we actually know a fair bit about what the Outer Space Treaty and the broader legal regime requires of us as space actors. And therefore, it allows us, that level of certainty allows us to actually focus on the outstanding questions that are very difficult, but maybe not the ones that we have necessarily, or you'll see in the media, spent a lot of words and a lot of time focusing on, because I think we do know more than we think we know. So let's see if I can prove that. Next slide. So when we talk about Article 2, or the broader concept of sort of being on the celestial body and doing things, I see sort of two subordinate issues there. They're highly related, but you can look at them a little bit separately. And I'm going to try to break these apart as I continue my discussion here, and then bring them together at the end. So I see two components, and the first is space resource utilization. And I know, COPUOS and UNOOSA have talked a lot about that. We'll talk about it more. And so that is one bucket of issues related to Article 2. The other related issue, and this is me expanding the concept of Article 2 a little bit, but it's just the implications of presence itself. Whatever you're doing, whether you're engaging in space resource utilization or science, or sitting around filming a commercial for a soda company, your very presence on a celestial body, whether it's human or robotic, I should say, has its own implications that need to be dealt with. So I'm going to try to analyze both of these questions, at least briefly. Next slide. And like any good space law and policy discussion, of course, we have to start with the Outer Space Treaty. And I know that all of you are aware of what the Outer Space Treaty says, but I did want to take a moment just to kind of pull out a few portions of a few articles that I think are particularly important and really need to be at the top of our mind. And I should say I've highlighted certain portions of these articles, but that doesn't mean I don't think the other portions are relevant or important. They absolutely are. I'm just, for ease of discussion today, I've highlighted the ones that I think you're going to hear about the most from me. So Article 1, it's the first article in the Outer Space Treaty. It includes a bunch of ideas. And the one I wanted to focus on here really is sort of two parts here in this middle paragraph that I've highlighted. One is the concept of freedom of exploration and use. Of course, that comes without discrimination, on the basis of equality, and critically in accordance with international law. So you can use outer space and explore outer space. And I think it's important to see that this article does say both exploration and use. What exploration and what use mean, of course, are open to interpretation, but it says both those things. And in accordance with international law. And there's other provisions in the Outer Space Treaty that sort of broadly incorporate concepts of international law as well. So that's there. And free access to all areas of celestial bodies. For our discussion today, focusing on Article 2, I think it's really important to highlight that freedom of access provision as well, because it's an important limitation on some of what you can do. And I'm sure Stephen will talk more about that later on. Next slide. Now, finally, we get to Article 2, the actual alleged topic of my presentation. It's really short, so I just highlighted the whole thing. Given the number of words that have been spilled talking about Article 2, the Article 2 itself is really pretty minimal. Outer space, including the moon and celestial bodies, is not subject to national appropriation by claim of sovereignty, means of use or occupation, or by any other means. And there's that word occupation, which is why it's in the title. But it's part of a longer sort of string of ways you can't engage in national appropriation. So the core prohibition here is on national appropriation. That's what you can't do. Now, what that means and what that prohibition is, we can talk about. But that is the rule. Next slide. Article 9 is basically always relevant to a discussion of space law and policy. There's a lot packed into this article. It is not, don't tell the drafters of the Outer Space Treaty I said this, but it is not the most well drafted of all articles because it includes a whole bunch of ideas that at the very least probably should have been broken into paragraphs, if not their own articles. But what I want to highlight here are sort of two related ideas, which probably should have been stuck together in terms of the text. The first one is this concept of due regard. States parties, so this would also include private sector actors via Article 6, have to conduct their activities in outer space with due regard to the corresponding interests of all other states parties. Again, what this means is open to interpretation, but at the very least, I think we could probably all agree that state actors and their private sectors, via the state, have to think about and potentially do something because there's other actors in outer space, right? You can't treat outer space like your own playground, let's say. And so due regard must mean something, therefore there must be some limits, and maybe Stephen will talk about this later on, but there must be some limits to what you can do, and you have to think about what the impacts are of your operations. And in particular, dropping down to the second highlighted portion, if a state party, and so again, this would include private sector, as a reason to believe that you could cause harmful interference with activities of other states' parties, is on the moon and celestial bodies or also in space, you have to undertake international consultations before proceeding. So interestingly here, the prohibition is not on harmful interference. The requirement is actually to conduct consultations before engaging in harmful interference. So that's an interesting distinction that I think surprises people when they first come to the Outer Space Treaty, that you actually are technically allowed to engage in harmful interference. You just have to talk about it first. So we'll talk through more what that means. But those two provisions, in my mind, go very much together: this due regard obligation and then the consultation obligation. Next slide. Then, of course, there's Article 8. This is the article about jurisdiction and control. And there's a lot of legal words in here, but it all boils down to the concept that just because you launch something into outer space doesn't mean that anything about jurisdiction, control, or ownership changes, right? So state parties, the registering parties, retain jurisdiction. They retain control over the object itself, people inside, just regardless of whether they're in outer space. I think that's the basic takeaway. Things don't change because you're in outer space. And crucially, this is about the object and the people inside it itself. It doesn't talk about the territory the object might be sitting on, for example, on a celestial body. It really is focused on the space object, like a lander or a rover or what have you. Next slide. Okay, so that's the basic background of the Outer Space Treaty. And I know many of you know that, but I think it's really important to kind of get all those pieces of the rules together in our mind in one place when we have this conversation. Here I'm going to talk briefly through the two components of Article 2 discussion that I see. Remember, I said at the beginning, I think there's issues related to space resource utilization and then issues related to presence itself. So I want to briefly talk about space resources and sort of highlight a few things that have happened internationally. I mentioned earlier that this issue really became hot in 2015 because there were a few startup companies, mostly based in the United States, that were talking and trying to raise money to engage in, at that time, asteroid mining, space resource utilization more generally. Most of those efforts did not pan out or come to fruition, but it got the international community talking about this. And now, of course, we're on the verge of some early stage space resource utilization, now focused more on lunar operations in support of scientific and other investigations. But the same rules and ideas, I think, would apply regardless. First thing I want to highlight that was a really major accomplishment I was proud to be involved in sort of a smallish way was the Hague International Space Resource and Governance Working Group. It's a long name and an even scarier acronym. But this, for those of you who don't know, was a really incredible multi-stakeholder effort hosted by a couple governments, but mostly universities. They brought together people from governments, the private sector, academia, the nonprofit world, to talk through space resource utilization and draft these building blocks, as they're called, which are some principles or ideas that governments could draw from. And it really was a very practical effort to identify, what we could say about what responsible space resource utilization would look like. So if you haven't read the building blocks, I suggest you Google them, read them. It really sort of kicked off this conversation in a useful way, rather than in a way that was sort of based on polemics. Then, of course, there was the Artemis Accords, and in particular, Section 10, which came out originally in 2020, and we've seen additional signatures since then, of course. I won't belabor that, although my next slide will talk in a little bit more detail about what the Accord says about space resource utilization. But the Accords were, at least to me, in my biased mind, a pretty substantial moment in the question of space resource utilization. Another thing I want to highlight, which has somewhat flown under the radar, although I'm sure many of you all know about it, is an award NASA made in 2020 to 4 companies for them to collect and then transfer ownership of lunar regolith to NASA. This was an incredibly small award. The total for these 4 companies was going to be $25,000. We'll see if any of them are able to do it. But the point here is that this was an attempt, quite frankly, I was one of the ones sort of who came up with the idea, so I'll tell you. The point here was to actually practice and test the legal concept of transfer of ownership of space resources, right? You don't have to bring them back to Earth. You don't even have to take them off the rover that collects them. You're literally just transferring the ownership itself, the legal concept of ownership. This is sort of a side mission or a secondary mission to some other missions that some private sector actors are engaging in on the moon. So that is in process. We'll see if any of them actually are able to collect those payments. And then finally, near and dear to, I know, all of your all's hearts, is the work directly out of the COPUOS Legal Subcommittee. And in particular, after a number of years of discussion on space resources, ultimately the formation of a working group whose work is ongoing and is going to engage in a very broad survey of the legal and policy landscape on space resource utilization. So that's what's happening internationally. There's been other things, but I think in terms of international multilateral efforts with a little bit of regolith purchase thrown in, I think these are the things that are most important. Next slide. I'm recognizing that we're short on time here, so I'm going to try to go quickly. Artemis Accords, Section 10 of it is the part about space resource utilization. Just to very briefly highlight what it says, basically that space resource utilization should be executed in a manner that complies with the Outer Space Treaty, but that the extraction of space resources does not itself inherently violate Article 2. So, the concept itself isn't prohibited, but whenever you do engage in space resource utilization, of course, you have to comply with international law. Okay, that's enough on the Accords. Next slide. All right, so that was my first bucket of concepts, right, about the space resource utilization itself. Now I want to really briefly talk about the second bucket, which is physical presence itself and engaging in activities on a celestial body. This one's going to be quicker because we have, in some ways, less developed sort of practice and policies here. Just a reminder, right, about the articles of the Outer Space Treaty we've talked about. So we do actually have guidance on a lot of things from a legal perspective. We know about jurisdiction, we know control, we know ownership, we know that the due regard obligation exists, and we know that consultations can be required. So another way to phrase that is, when you have physical presence on a celestial body, we know what you have, right? Jurisdiction, control, and ownership. We know what you must do, give due regard. We know what you, and you must engage in consultations. We know what you can't do, which is national appropriation. So there's actually a lot of legal things we know. What we don't have is substantial practice in dealing with this stuff in the real world, because we haven't really seen overlapping presence or activities on celestial bodies, right? We haven't had missions that are doing things in the same place at the same time. So we haven't had to sort of put this into operations. So that's the question, right? We have rules, we have legal rules. How do you put them into practice? Next slide. What the Artemis Accords tried to do to answer that question was to create this concept of safety zones. I'm sure many of you have heard me say before, we probably should have called those something different because they really are just notice and coordination areas. All the Artemis Accord says in section 11, and it's too long for me to put on the screen, so I didn't do that here. But really all it says is, if you think there's going to be interference in your operations, or that your operations could cause interference, then you need to tell the world where you're going to be, what you're going to be doing, and commit to providing notice and coordination back and forth with anyone else who's going to go in the area of your operations. It's really a way to implement the Outer Space Treaty obligations through a more detailed mechanism, a more transparent mechanism, provides global notice rather than sort of sitting back and waiting to see if someone else comes and talks to you, and requires signatories to give detailed justifications for why they might say they're owed due regard, or why interference is possible. So it fleshes out, and I would say creates a greater burden on actors than the Outer Space Treaty itself says. Next slide. So this is where things stand, just to sort of bring things all together here. On space resources, I would say the focus now is not on whether you can use space resources legally, but on how to do that responsibly, how to do that in line with legal obligations. And we're in a similar boat regarding the concept of presence and activities. How do we implement our legal obligations in a way that's practical, and I should say supports continued space activities, right? In a way that doesn't chill or deter things that you don't mean to chill or deter. Next slide. I'm continuing my summary here. This is what we know. We know, at least I would say, that it's pretty clear the international community has, not everyone, but a substantial chunk of the space community, including governments, have crystallized around the idea that you can own extracted space resources. I think everyone agrees that control and ownership of space objects continues. The Outer Space Treaty says that. You can't claim sovereignty over territory. That's very clear in Article 2. You have this obligation to give due regard and this obligation to consult. So these are the things that I would say we know pretty clearly. Next slide. So the bottom line here, and this is where I get back to my thesis, is that I think we actually do know a lot of things. I think we know more than we admit to ourselves, and particularly we know what our legal obligations are, which means, at least in my mind, is that the focus can and should be on operational and policy questions. And in particular, I would say we need to come up with some creative solutions to how we implement our obligations that encourage all forms of space activities. And I'll give you a few examples, and I don't have answers for these, but I want to give you these examples because these are some questions and the kinds of questions I think the space community really needs to focus on. So one is, how do you actually manage sales of space resources? NASA has tried to start that with the regolith purchase, just to kind of kick off that conversation. But a difficult question I'll throw out to you all, and again, I don't know if it's possible to respond to this or how you would do it, but we've seen the private sector ask for some way to get certainty about space resources. And what they mean by that, at least what I've heard, is private sector actors would benefit from having some level of certainty that if they're planning to extract space resources, maybe to sell water to NASA or some other space agency for exploration on the moon, they'd like some level of certainty that the region they're targeting won't get used up before they get there, or that someone else won't displace them or show up before they get there, and therefore their investments and all the work they've done would be wasted. So, that call for certainty from industry, some level of, some people have called it priority rights or other terms. I don't know if there's a way to respond to that within the current legal framework, but you can imagine that if there were, it would certainly make it easier and safer, frankly, to plan for operations, get investment, that kind of thing. So there's one question that I think we need to focus on. Another one is, how do you actually implement these obligations relating to presence itself? How do you implement due regard and consultations, particularly in the context of commercial actors? Governments know how to talk to each other. Sometimes we don't as much as we should, but we do know how to do it. That gets a little more complicated when you're, a step or two removed from those direct government-to-government relationships. So how do you bake in outer space treaty compliance into private sector activities? I think that's a really interesting one, and one that Office of Space Commerce is going to be highly involved in. Next slide. So my final thoughts, and this is really homework for everyone, I think, and it's the way I try to think about space law and policy, and it's what I would suggest we think about as we move forward. And it's not actually to start with the Outer Space Treaty quite yet. We'll get there. But I think it's important to start first with the future we want, right? Whatever that future is, whether it's a highly commercialized one, whether it's one focused on exploration or science, whatever the future is that you want, I suggest you start with that. Don't get distracted by questions that already have answers, right? As I've said throughout this presentation, we actually know a lot. We know a lot about the legal rules surrounding celestial bodies. So I would say don't get distracted by those. All right. Even if you wish the answers were different or would write the Outer Space Treaty differently, I know I would. It's the law we have. So I would say those conversations are actually not that useful. So imagine the future, don't get sidetracked. And then it's time, I think, for all of us to get creative. There's a lot of operational and policy questions. I've only highlighted two, but there's a bunch of those. And I think we need to think through what's possible. And as we do that, I think it's really important to not feel like we have to have perfect answers yet. This regolith purchase, for example, we thought of it as a policy prototyping exercise. And I think that's okay. I think we are going to have to recognize that we're learning together as we do this stuff. Operations and policy require practice just as much as engineering does. And this is something I think we haven't let ourselves accept as much as we should. So I think it's okay to come up with ideas that maybe are attempts to see what happens. And then if they don't work, we can come up with a different idea, operationally or policy based. And then finally, governments and even the traditional space community itself, so all of us in this conversation, frankly, because it's probably space people on this call, we're not going to have all the answers. And we definitely don't have all the equities for these issues, right? The entire global community, sort of all of humanity, has equities in how we handle celestial bodies. And there are a lot of lessons to be learned, both good and bad, sort of useful and cautionary tales from the rest of human experience. So we need to broaden this conversation. There's been good efforts. The Hague group in particular was a huge step forward in that direction. But I think we're going to have to look a little bit outside the space community to help answer all these questions. So I think that is a last slide. I know that I've gone pretty long here. If we have time, I'm happy to answer questions. But I do suggest you all take those sort of final thoughts as homework and a way forward on this conversation.
Gabriel, thank you so much. And it is so enlightening to hear your perspective on this. And we've been rolling around through these issues, a lot of these, and thinking about, soul searching and trying to find a way that we can square all of these disparate ideas, let's say. And I think it's really interesting, your approach on this. And look, I will say that I put occupation in use. It's clickbait. I did that.
It's in the treaty too. What are you going to do?
Yeah. I know. But what I wanted to hone in on was this notion that all states that are planning to do this, they have an interest in similar outcomes. They have an interest in finding a way to work together to to recognize their shared interests and of limited space, really. And this was brought up in one of the comments as well, the chat, on the South Pole of the moon. This is something that we've all been looking at. You know, this is going to be quote unquote the contested area. Let's say we don't like to call it that necessarily because it offers an opportunity. And, you know, having a way that we can think about how we deal with space resource utilization in a way that is sustainment of those operations. This comports with all of the back ideas that have always been there, even into the Moon Agreement, of, you know, for scientific studies, for these missions to find a way to sustain those missions. And I think that that's a real starting point to square a lot of this, is that that's necessary, and it's going to be necessary for any players, regardless of how they might feel about the commercial transfer of ownership and all of these other sorts of things that will likely come in some way or shape. And like you say, we have the treaty before us. We have a lot of features that need to be explored. And one of the questions that I have for you is what are your thoughts on the use of Article 11 to facilitate this notice function of this is what we're going to do, this is where we're going to do it, a temporal limit, let's say, this is how we intend to explore this particular celestial body, so that others are on notice of what that activity is, so they may pay due regard. They will know what regard is due under the circumstances. What are your thoughts on that as a mechanism of our existing framework that we already have to facilitate these activities? Thanks so much.
I appreciate you highlighting that, and thank you, Michael. I think Article 11 is a very sadly underutilized part of the Outer Space Treaty, and I think it's a huge tool. You know, one of the motivations behind the Artemis Accords, and in particular the sort of due regard and non-interference portions of it, was to create transparency in how states implement our obligations, right? By providing sort of a regime of notice. And the Outer Space Treaty does give us a tool like that, right? Article 11 gives all states the ability and arguably obligation to provide the international community with details about our operations. And almost none of us, frankly, do it in a formal way. I think most governments would say that we meet that obligation through reporting to the UN through other channels, you know, whether it's in remarks at COPUOS or otherwise. But that could be fleshed out in a formal process. I know that there's been some efforts through the Article 11 project to examine what that could look like. And I think it would make it so much easier to implement the obligations we already have, because everyone would know what plans are, who's doing what, where. I think it would really move us away from a reactive stance, which is kind of where we are now. Sort of, oh my gosh, there's two missions in the same place. Now we have to implement due regard or whatever, to a stance in which we can plan and we can have those consultations well in advance. We can see justifications publicly. You know, why do you think you're going to kick up regolith for 100 meters? Well, this is because this is the location, this is the details of the engine or whatever, the rocket motor. So I think it's an enormous tool. I hope it grows. Now, this is my personal view here. I think it's a tool that governments should start using much more than we historically have. Yeah, so thank you for mentioning that.
Exactly. And, you know, we will have a bit more discussion on this under this particular Article 11 and the context of, you know, the nature of information sharing, the triggering mechanism of this consultation under Article 9. This way of implementing this so that we are all more together on the same page about what we are doing and how we can coordinate that. And just on another sort of note, do you see that there could be the usefulness, especially with the growth of potentially more private sector actors, more other states getting involved with this, with lunar activities, that there could be a consultation mechanism that could be another, almost like we have the treaties, we have resolutions, we have principles. As a progressive development of space law and governance, would that be something that would be useful for states as even almost a standing committee or in its own right? I know we have the committee on GNSS, the ICG, There's been a lot of talk about ICG for lunar activities. Is that something that you might consider useful, and even just as a framework for attacking this kind of thing, and even putting a way of addressing some of these ideas? What are your thoughts on that?
So what I say here is definitely going to be my own personal views. I know there's a number of proposals floating around, and I think at least one of those proposals is on the agenda for COPUOS for this coming year. I think those are a really interesting idea. One, they're certainly not legally required. You don't have to have a formal consultative mechanism. So I think the question then is it useful? You can see clear potential benefits. I do think there are some potential downsides and ways that could go wrong. You would not want to create a process, for example, that allows itself to be abused by, trying to effectively claim access or displace other actors by tying up a consultative process. And so there's a little bit of danger that the more formal you make something, in some ways, ironically, the more open to abuse it can be. So I think, like everything in the multilateral system, details are going to be really important. Of course, it's going to be important how broad participation is. Also, if you don't have all the major actors, then it actually would become almost less useful than having what we have now, sort of informal mechanisms. So it's very tempting. If you're asking me, Gabriel, I'd probably say let's try. But I think it needs to be fleshed out a little bit more, because you really don't want to create a system that could be abused and in effect violate some of these articles, or just engage in bad acts, but because you're trying to do something well. So I think it is really interesting conversation. Definitely it deserves scrutiny. I hope that we can, in an ideal world, that's exactly what we would move towards. So I hope the international community has it within itself to be able to pull that off.
Absolutely. And look, I really want to thank you for your thoughts as well. It really means a lot to us in our continued work. You were there at the beginning of this working group on the space resources and negotiated that very well with our Chinese friends and colleagues. And we have now found a way that we think we can get more the voice of private actors, non-state actors before the committee, in a way that is of course palatable to all states, and for their consideration in trying to really come to grips with how to deal with this, because like it or not, those actors will be there, and it will shape how we all coordinate, we all work on things in the future. And just because I see this in the chat, and I would like to know this as well, what is the extra dollar for?
I saw that in the chat too, and I have to say I don't know actually. I was at the State Department then, and then sort of helped design the idea, and then implementation ended up going through NASA contracting channels, right? It was sort of so I think it has something to do with sort of government acquisition rules, quite frankly. That's something I should spend some time digging into. But I'm 99% sure it just has something to do with either what the NASA budget was like at the moment, or something having to do with dollar amounts allowed in federal acquisition rules. Frankly,
Yeah.
it's an interesting question. It wasn't like there was nothing sort of like clever behind the number. Let me put it that way. It came about for some sort of bureaucratic reason.
Oh yes, as most of our things do come about, it's quite an interesting thing. But look, I really want to thank you again. We've run over a bit of time, but I think it's really interesting, and I think your perspective is really interesting, and we really hope that that more space situational awareness data comes out of the Office of Space Commerce, that is going to really help orbital activities immensely, and we are really looking forward to finding a way to also coordinate on those activities. That's a whole nother chapter of things that is coming as well, and that we'll be discussing over these next few days. And really, it's just a real pleasure to see you again, and we really want to welcome you back. The next time you get to come to Vienna, we really look forward to it. You got to come and do some presentations for us in the committee. We're coming up on some really interesting times ahead of us, where authorization and supervision is going to mean more and more, and your work there will be very much appreciated, and very interested. We're all very very interested, actually.
Thanks, and thank you all so much. And yes, the Office of Space Commerce, we're staffing up. We're getting more engaged. We have to. So I am looking very much forward to engaging with the COPUOS and UNOOSA and the entire multilateral system, perhaps more than we have to date. So you will see me again, hopefully in Vienna and otherwise. And I'm really excited to sort of be back in this world again. So, and thanks for all the friends and colleagues I see online as well. I'm sorry I haven't been able to get to everyone's questions, but this has been great. And I'm sure the rest of today will be as well.
I really appreciate it, Gabriel. Thank you again, and have a great day.
Likewise.
This is really terrific, and really, it's a real pleasure to have such great speakers. And in a way, I mean, given our difficulties that we've had over a number of years with, of course, with our collective issues with COVID and everything, we've learned one thing is that we can really bring a lot of people together in this kind of format that we would not ordinarily get to see. We wouldn't get to bring so many people and have such a wide reach as well. And it's a real testament to our resilience and our ability to do things. And I really appreciate everybody coming in with sharing a bit of their time, even if it's really early in the morning. I know our great folks in the Americas have helped us out with this. And of course, we will hear also from our great colleagues in the East as well. Anyway, I'm really happy to have a little bit of chance to chat on all of this. And now I would like to be able to call on our next presenter, our former chair of the legal subcommittee, Mr. Terry Bersibe. He is, goes without question, so many great times we've had hearing his views, and I really want to welcome him to share a few views on Article 3 on, of course, international law and space activities, and of course the UN Charter, Article 3 under the Outer Space Treaty. Terry, I see you there. Would you like me to share your slides from my side?
Well, firstly, I hope you can hear me.
Yes.
Good day.
Yes, we can.
Very well. Thank you, Michael. And yes, I'd be delighted if you could take control of the slides from your end.
I'll do so. See if we can get these. So thank you so much again. Let me put this on presentation and let's see what we can do. My goodness. With all of our benefits, we still have challenges, I can tell you. Let me just see here. Here we go. Sir, thank you so much. Please, you have the floor.
Thank you again, Michael. Let me begin by expressing my appreciation, as always, to the hosts and organizers of this United Nations Conference on Space Law and Policy, themed the Outer Space Treaty for the 21st Century, organized by the United Nations Office for Outer Space Affairs. The topic I have been asked to speak on concerns international law and space activities in the context of Article 3 of the Outer Space Treaty, but specifically as it concerns acts and omissions as breaches, presumably of that international law applicable to space activities, and the enforcement as a way of treaty obligations. So on the next slide, we have an outline with an overview of what it is the rather short presentation will address. And we will begin with an overview of what the international law that is applicable to outer space activities constitutes. I think this is an appropriate starting point in order for us to then be able to identify what acts and omissions could then constitute breaches of the obligations now applicable to states within the context of this overarching international law. More specifically, then, we will look at how treaty obligations could be enforced, and then conclude the presentation with some remarks. So if we proceed to the next slide, as I indicated, in identifying those obligations that have been breached, and before we go to specifically acts and omissions, I think it's necessary to recall that body of law that we consider applicable to outer space activities, because it's actually international law. And in order for us to appreciate the breadth and scope of this body of law, that we begin with the guidance that's provided by the Statutes of the International Court of Justice, specifically its Article 38. The reason being that, in as much as this article is probably well known to almost everyone, students, practitioners, academics of international law, but it summarizes and highlights in no particular hierarchical order the various sources of international law: treaties, custom, general principles, resolutions, doctrines of legal specialists, which clearly can be used as a comparison to identify what the sources of the same international law but applicable to outer space activities would be. And in that regard, you find certainly the 5 United Nations treaties, which have been referred to extensively already by preceding speakers. And without limiting ourselves to these 5 United Nations treaties, I think it's also important to make reference to the literally thousands of bilateral agreements, as well as other multilateral agreements that guide and govern the relationships between states in their either individual or collective conduct of activities in outer space. There's a significant number of resolutions. There's quite a bit of custom, in my view, and most recently, a number of guidelines and recommendations that continue to be adopted, principally by the Committee on the Peaceful Uses of Outer Space and perhaps other bodies, international bodies, that is. So on the next slide, for the sake of illustration, and as I indicated, without adducing any particular hierarchy between these respective sources over one another, you will see that the reference specifically to the applicability of international law, or the recalling of the fact that international law is applicable to activities in outer space, is identified in a fair number of instruments in the form of United Nations, either assembly resolutions, declarations of legal principles, some of which actually predate the Outer Space Treaty that constitutes the focus of this panel and this presentation in particular. On the next slide, I think it's important to also highlight the fact that there are a fair number of principles which, having begun, have evolved from the resolutions in which they were initially adopted back in 1963 and reproduced verbatim and codified now, that could, without a doubt, be considered as applicable customarily in the comparable provisions of the Outer Space Treaty. And so, for instance, we see with respect to Article 3 that its origins would actually be traced to the second principle in the General Assembly resolution that was adopted in 1963. On the next slide, focusing now on Article 3 in particular, which is a lot more explicit around the commendation to states to carry on their activities in the exploration and use of outer space, including the moon and celestial bodies, in accordance with international law, as well as the Charter of the United Nations, towards certain very clear objectives, maintaining international peace and security and promoting international cooperation and understanding. I think we should also recall the provisions of Article 1 of the Outer Space Treaty, considering again the commendation that the exploration and use of outer space and access to it shall be free without any discrimination on the basis of equality, and again in accordance with international law. So we have this recurring reference to international law that runs through the various identifiable sources of international space law, whether they be resolutions, whether they be customary principles, whether they be considered treaty provisions, and so on. Having provided that backdrop or context against which international law is applicable, on the next slide, more specifically now, the question of what an act or omission constitutes in terms of a breach, and we can use the word breach or term synonymously with a violation, to my mind presupposes that there is a duty to perform an obligation that is not being met, as it were, but which, strictly from an international law perspective, invokes a principle, and that principle is known as responsibility. But we don't interpret that principle or term in a simplistic fashion, because there are multiple aspects to be considered when you look at the principle of responsibility. Firstly, you need to look at state responsibility. It's a technical term, which really means, if one is guided, of course, by the articles on international responsibility for states as a consequence of internationally wrongful acts, then responsibility is really that culpability towards another state, but for which there would need to be two criteria in order for that responsibility to be established. The first being that there is a breach of an international obligation or violation by a particular state, so let's call it the state that is now responsible, with respect to the interests of another state, and that breach or violation has actually taken place. The second criteria to establish, if this principle of responsibility arises or has been invoked as a consequence of a violation or breach, is that the breach or violation, as it were, is attributable to the, as it were, state that is responsible under international law. And this is important because as far as this particular principle of international responsibility is concerned, from a purely general international law perspective, and how this principle is interpreted and applied, it would mean that the mere attribution of a breach or violation of an international obligation, regardless of where that obligation stems from, given the various sources of international law, and without the fact that this violation or breach, very different from how you would establish culpability as an individual, or say in a domestic legal context, where you would want to establish the intention, that is subjective. So without any fault, added to the fact that without having caused any damage, because you would assume that a breach or violation leads to some state suffering in some form a loss or some kind of consequence that displaces it from a particular state of affairs. But in fact, in this instance, without fault and without any damage being caused, whatever the exact definition and scope of that term could be, which is very wide-ranging, so long as there has been an identifiable violation and that violation is attributable to a state, it is enough to incur responsibility. firstly. Secondly, and I think we should spend a bit more time on the topic of attribution, because this is really a very important element, and we see the importance of this element when you make a comparison between the interpretation of international responsibility on the general principles of international law and how that term international responsibility could be applied in the international legal framework that is applicable to outer space activities that we identified at the start of this discussion. So, in fact, typically, a state can act through its organs, its institutions, its parliament, its courts, its authorized officials, and so on. And so, specifically, conduct would be undertaken by those organs. It could be a ministry, a parastatal, a diplomat, whatever their position and their character is. But that act is attributed to a state, and so is the conduct of persons that are exercising elements of governmental authority. This is how you would establish the attribution of the breach in question to a particular state as being responsible, because it is conducted either by individuals subject to governmental authority or through organs of a state. On the other hand, within, again, this general principle of international law and how responsibility is interpreted, the state is not necessarily responsible. This is a difference from the outer space regime for acts of private individuals. So these are not necessarily government officials, individuals such as you and I in our private capacity, going about our daily business, except in certain circumstances. And those circumstances, again, are worth highlighting because it implies that exceptionally there could be the need for a state to have applied what's regarded as due diligence. So, in the event that a state is required to prevent specific private acts, so ordinarily, the state is not responsible for those private acts, but if it were required to, and those private acts then result in violations or breaches of international obligations, and the state has clearly failed to take a particular step or act, then it triggers responsibility. So this, as it were, in the larger context, is a corollary and a direct consequence of the continuing jurisdiction that states exercise over their territory and their nationals. Thirdly, and you will recall, I had highlighted there are three aspects here when we look at the question of responsibility is, so there's been a breach or a violation, and so what are the consequences? What does this lead to? Once responsibility has been established because there's been a breach or violation, and because that breach or violation can be attributed to a particular state. So the legal consequences, again, if we restrict ourselves to the guidance that's provided by the articles that were developed by the International Law Commission and adopted by a resolution of the General Assembly, it does include a duty to desist, to stop from continuing or repeating whatever that breach is, firstly, as well as the duty to repair the injurious consequence of the breach or violation. So typically you would want to restore the state of affairs to the original condition that it was before the breach or violation occurred, and to the extent that that may not be possible, then there would need to be the payment of some compensation in full, and perhaps where again that might not be totally possible, as an alternative, that the victim state is satisfied in some form. That does not necessarily involve the payment of reparation for material damages that it's caused. And so the establishment, I think, in summary, of responsibility under general principles of international law are quite peculiar, given the fact that you could actually have a state that's deemed responsible without necessarily having intended to have caused any damage, without any damage having been caused whatsoever. But the mere fact of a breach or a violation actually triggering responsibility, distinct from state liability, which again is not really a concept that exists, because liability, and we should avoid making a comparison between how states, international entities are deemed to be liable, and how individual persons, you and I, private citizens, will be liable, and how that liability is established. But with respect to states and their international liability, this is generally perceived as the obligation to pay compensation or to make reparations, such as I described earlier, to restore the situation to the state in which it was before the breach or violation occurred, as a consequence of certain acts that has resulted in injurious consequences. That would have been suffered, either by non-nationals of the state, or perhaps has resulted in those injurious consequences beyond the boundaries or borders of the state in question. So the concept is really clearly related to damage, and it doesn't, unlike the establishment of responsibility, stem from a simple violation or breach without any fault or damage that would trigger such violation, as we'd indicated earlier. So against that backdrop, on the next slide, if we come back to the focus of this discussion and the acts and omissions as violations or breaches, but within the context of the international regime applicable to activities in outer space, particularly the Outer Space Treaty, which we focus on, not because it's the only instrument, but because it actually has language in it that identifies international responsibility for states, albeit as a consequence of national activities. So the traditional concept of international responsibility that we saw earlier on, where you have a breach and a violation, and the attribution of that breach or violation to a state with or without fault or damage, is actually quite different here. It's different because the concept of international responsibility is widened. And here, what Article 6, which is the sole provision of its kind that refers to this principle of responsibility, introduces it as a consequence of national activities, which is a very broad term. Firstly, added to the fact that it encompasses national activities, whether they be carried out by governmental. So if you recall, in the broad general international legal context, we made reference to organs of the state, the institutions of the state, or government officials. In this instance, you actually have the application of this principle, or the consequence of this international responsibility arising from national activities, whether they be carried out from governmental or non-governmental entities. This is the first point of departure from this specific international space law regime, worth highlighting, in the context of acts and omissions as breaches that you see when compared to the overarching international interpretation of the principles of responsibility and liability. On the next slide, likewise, we have Article 7. And here, I think I would be preempting a discussion, because I understand there are other speakers who will be looking at, in particular, the liability provisions in the course of this conference. But suffice it to state at this time that we have here Article 7, in addition to Article 6, but which in this instance actually makes for international liability of launching states. It's a very specific term with respect to damages that are caused by their space object. So the focus of this discussion will not go into what space objects mean, what states or combination of states would constitute launching states, because that would require a lot of time. But simply put, and based on these provisions, which have been elaborated on in a lot more detail in the Liability Convention, we see here the key point to highlight that there really isn't a differentiation between lawful or unlawful acts. So we had, the possibility for responsibility to be, attributable as a consequence of the breach, regardless of whether there's fault or whether there's damage. We don't see that distinction here. That might well be because you actually have, activities being undertaken in a peculiar realm, which could be considered as inherently hazardous. Might well have been the perception very early on when the framework was being established, because we shouldn't forget, in as much as this international liability for damage caused as a consequence of or with respect to a space object that is attributable to launching states was adopted in 1967 in the Outer Space Treaty. It's actually predated by a comparable principle that you'll find in the 1963 Declaration of Legal Principles, Declaration 1962. And so there is a need, or rather what the framework does, is very clearly, well, back in the day, establish, or what it did back in the day was establish a very clear liability regime without any differentiation between lawful acts or unlawful acts. And rather, you have a regime whereby liability is literally strict when damage is caused either to aircrafts in flight or on the surface of the Earth. And in the event that damage is caused in space, then it will be based on considerations of culpability or fault. So having looked at this differentiation between the triggering, as it were, of responsibility and liability, and how that differs in the regime applicable to outer space activities from that applicable to general principles of international law, the question that follows is how, to the extent, if any, that these breaches or violations could be enforced, at least as far as treaties are concerned. And that takes us to the next slide. So with respect to enforcing treaty obligations and not forgetting the principle that states are bound to comply with their treaty obligations in good faith, there are various possible mechanisms by which treaty obligations can be enforced. I've listed a number of them on the slide you see before you, and this could be through tribunals such as the courts, such as the International Court of Justice, because we shouldn't forget the applicability of international law that is enshrined in Article 3 of the Outer Space Treaty also makes reference to the Charter of the United Nations. The court basically being, the principal judicial organ of the United Nations as a means by which, all of its member states may settle their disputes peacefully. So certainly, in accordance with international law, of course, so certainly treaty obligations arising from or related to the respective treaties applicable to outer space activities could be adjudicated upon, assuming, of course, that states accept the jurisdiction of a court to that International Court of Justice. For instance, states could also entrust the settlement of their disagreements, which would be a corollary of how obligations are enforced, perhaps to specific dispute settlement mechanisms that the treaties themselves establish, such as what we see in the possibility to put forward claims for compensation, which the 1972 Liability Convention established is one example. You also have the possibility for measures, sanctions, as it were, that the United Nations Security Council could impose under its the Chapter 7 of the Charter, that is, to enforce its decisions, perhaps regarding or as a consequence of threats to international peace and security, perhaps or breaches of the peace or acts of aggression, and which is not arbitrary, because we've seen, for the sake of illustration, the imposition of sanctions under these Chapter 7 type circumstances on some countries that are in the process of launching missiles that would constitute threats to international peace and security, for example. So in conclusion, which takes us to the very last slide, I think it's apparent, I hope now, that acts and omissions as breaches of international obligations could certainly clearly be identified within the body of international law that is applicable to outer space activities, that the principle of responsibility and the obligation to sort of make good any violation as it is interpreted and applied under the general principles of international law probably has a much broader connotation when the legal instruments or the international instruments applicable to outer space activities are concerned, and in which you see a much closer relationship between international responsibility and liability for damage. But I think overall, if we revert to the premise on which we're having this discussion, which is, international law, outer space activities, acts and omissions as breaches and enforcement of treaty obligations, the conclusion or the highlight is there really isn't, an overarching, compulsory or coercive judicial or penal system that addresses, breaches of treaties or, proposes to somehow settle disputes, because states are sovereign and you can't really compel states, as it were, to perform these obligations. Having said that, there are multiple mechanisms, depending on the circumstances, the instruments in question that are applicable to the acts or omissions that constitute breaches or violations that have been identified, to which one can point in order to enforce these obligations. So that brings us to the end of the presentation. I, again, would like to thank the organizers for the opportunity to speak at this event, and I'd be happy to take any questions that you have.
Terry, I really want to thank you so much for bringing it all back home in a true, international law context, because that's really where we are. That's really where we stand with trying to come to grips with how we deal with the Outer Space Treaty. And of course, it is in international law, and there are the features of the UN Charter, and there are features of general principles of international law that apply. And I would just like to recall something and maybe ask your thoughts on this. There's been a lot of discussion and debate, and I've had this with our numerous of our good colleagues about the extent to which acts of non-state actors can be attributable to the state in the context of space activities, especially because those acts of non-state actors, we see them as the acts of non-governmental entities under Article 6. And so if there is this responsibility or this duty placed upon states to authorize and continually provide continuing supervision of those space activities of non-governmental entities within their jurisdiction of their state. To what extent are the acts of those non-governmental entities imputed to the state? This is a very interesting form of consideration now that we see the rise, of course, of more and more non-governmental actors. And there are some, of course, this was a compromise provision, and I alluded to this before in my talk about how, you know, the original Soviet Union proposal was that activities in outer space could only be performed by a state. That was their original proposal. And of course, we see this as compromise into the 1963 Declaration, and we see it memorialized, of course, in the Outer Space Treaty. And so this notion of where is the line drawn between these, okay, we have national activities, but then we have the activities of non-governmental entities, but where can we hold states responsible for their oversight? And that's what I was getting to in a lot of ways with this idea of omissions. If a state fails to potentially supervise, and almost as a codification of the original Corfu Channel case, the ability or the use of its own territory that could cause damage to another state, that is essentially what we see. So the duty is on knowing what's going on in your own country, being responsible for those things. Yes, being there to respond to challenge it, to say, what have you been doing? And then, of course, those being able to point to the acts of a non-state actor, say, well, that's not my act. What are your thoughts on where that line is drawn? Thanks.
Thank you very much, Michael. And you basically gotten to the heart of the matter. And I think, simply put, there is no line. There is no line because in the absence of more specific provisions, you know, these rules of really public international law apply based on, simply put, what we have in Article 3. More specifically, at least until we have perhaps a more elaborate interpretation of what national activities constitute, we can only conclude that this must necessarily be deemed to encompass activities carried out by nationals and activities undertaken from within the territory of the state in question from a jurisdictional standpoint. But that doesn't make any distinction, you know, or in any way isolate, you know, independent acts of non-governmental entities. Because I think perhaps one aspect of Article 6, and that's the beauty of Article 6, in my view, is that it goes on to establish a duty for states to authorize and continuously supervise all non-governmental, let's call them private activities, added to ensuring, as part of that duty, that they're carried out in conformity with the provisions of the Outer Space Treaty. So, in fact, the identifiable entity, the only identifiable entity, as it were, that could be deemed responsible is the state. And I think this, you know, what Article 6 does, it makes it very clear that the state has a duty. So if you take a step back, you know, and you perhaps look at your question from another context, it underscores, you know, a fundamental requirement for states to implement these obligations that they have assumed by either becoming parties to the treaty or because, you know, specific treaty provisions have become customary and are of general application, to actually adopt mechanisms, you know, by which the activities of these non-governmental entities can be authorized and that those activities can continually be supervised. So, summarily, there is no line, and the, you know, clearly identifiable responsible entity here, at least until, or in the absence of some elaboration on what national activities constitute, and perhaps, a finer differentiation between governmental entities and non-governmental entities will always remain the state in question. This is my view.
Right. I mean, in fact, by looking at a lot of this stuff in preparation for this conference and doing some background looking, I come across some early proposals of the United States, of course, in liability, and this notion of absolute liability. And this was, of course, there was debate on this in the early, 64, 65 period. And Belgium, of course, came with an interesting way of looking at it, said this is state between state, and there's no question about it. And that's the only way to really look at it, is that is the actors we are talking about, and those are the players who are, at the end of the day, those are the ones going to be responsible. And this notion, echoing, of course, the Soviet Union, but then making compromises to understand, okay, well, we know that these other actors have ambitions and we want to make a playing field for those. And then having the duty incumbent to say, okay, well, even so, there must be someone responsible as part of the way of making basic principles that allow space activities to be undertaken as a legal activity in itself. There must be someone responsible, potentially someone liable if damage is caused. And there must be tracing mechanism to determine, okay, well, who is it that we must go to? And having those features in this framework, I think makes it incumbent on states to be aware of what is happening in their jurisdiction, regardless of whether that is happening from an individual, a private sector entity, whether that as you say, it's someone under the jurisdiction of the state, whether that's territorial or personal. As we go back to our fundamental principles of how we establish jurisdiction, and so whether that takes place in the territory or outside the territory, if it's by a person who is a citizen, possibly, or a company that's organized under the laws of a certain country, there must be some country, there must be a state who's responsible. And I think that I'm always interested to see where the lines are drawn. And as lawyers, as in the law, we always want to have some kind of certainty, but we often are dissatisfied. And I think that, when it comes to these line drawings, at least states can recognize the fundamental framework that they must be responsible for what happens in their own backyard. And I think that is the key to at least understanding this and understanding that duty, that oversight mechanism. And I hope that, and of course, this debate will rage on. We will always evaluate the activities of those and under a framework, under this framework that we have, either under the specific ideas under this treaty or under general principles of international law. And your laying out of this entire framework is so instructive. I mean, sometimes we get into the weeds of our, what we are focused on, but drawing back onto these real principles of international law, I think has been so instructive. And of course, we have in our next presentation, which we'll get to in just a moment, our good professor, Stephen Freeland, who will also tell us about all lines being drawn and what it means in appropriation and non-appropriation of celestial bodies in the moon. But one thing, let me see if there is a question we can get to from our chat before I overtake the microphone completely. So why states were not able to agree on overarching settlement of disputes in space law? I mean, why is it resorted to at least this feature of, say, the International Court of Justice or something like this, when in the Outer Space Treaty, why do you feel in a way that this was left out when there are so many other treaties that have dispute resolution mechanisms? In fact, even the Liability Convention has one, and with its commission and everything. Maybe spend a couple of words on that, if you would be so kind. Thank you.
Certainly. I think, firstly, it's important to appreciate the fact that the reference to possibly resolving disputes through the principal judicial organ of the United Nations is a consequence of interpreting the application of a charter, because the treaty is not limited to the charter. The treaty, for instance, but for the sake of illustration, commands states to consult amongst themselves. And we shouldn't forget, within the rubric of the Pacific settlement of disputes, in fact, consultation is probably the oldest mechanism for the settlement of disputes, on the one hand. On the other, we see a more elaborate framework that's been outlined in various provisions of the Liability Convention. And that in itself has multiple elements to it. It offers, parties the possibility to resolve this dispute through diplomatic channels. It offers the possibility for parties to put forward, their claims for compensation. And in the event that, that is not successful, that they perhaps resort to a claims commission, for instance. But outside of, in addition to, these possibilities, these mechanisms for the resolution of disputes, I don't think that we're limited to these instruments. I mean, I recall being part of a process shepherded by the Permanent Court of Arbitration that led to the adoption of, rules of arbitration, which, to my knowledge, multiple entities, both private sector and intergovernmental type entities, are adopting, that provide the opportunity for, parties resolving their disputes, including states, to take those matters to an arbitration panel, for example. So I think, in summary, the notion that there is a reference to the International Court of Justice is probably limited. There are multiple mechanisms that you can point towards or look at in order for states and intergovernmental organizations or private sector entities involved in disputes with states to be able to resolve and settle these disputes.
I'm so glad you mentioned that, because in fact, of course, what we have in the Outer Space Treaty, Article 9, we have a consultation mechanism, both mandatory and permissive. And it requires examination of a state's own activities in relation to the activities of other states that it has, of course, knowledge of that. And so there is this mechanism is something we're going to be talking about more in the conference when we get to Article 9. And this was a sticking point in the negotiation of the treaty. The treaty, of course, is a product of consensus. And very much like as your experience in the legal subcommittee, you see how hard consensus is to be reached sometimes. This was something that this dispute resolution mechanism was of course not something based on consensus, mandatory dispute resolution mechanism. So then it became this this consultative mechanism that was, of course, the oldest, like you say, the oldest of all international law and international relations that go before. So really, I want to thank you again for sharing your views. It is always so instructive to have your contribution to our Space Law Conference. I note that your experience in international law is very is wide-ranging and very deep, and we really appreciate to have this. I noticed that there were some also in the comments asking for more, essentially for more contributions of deep international law experts with respect to the activities of states in outer space, and really applying that firm international perspective, international law perspective. And of course, you also bring this up, and this has been brought up before of others. We have another former chair, Sergio Marchisio, Professor Marchisio, who will be talking about due regard, which is, of course, another very deep international law concept that finds its way into Article 9 as well. We'll be hearing about that later on in the conference. And really, again, thank you, Terry, for your contribution, for spending time with us today, and we really do appreciate it very much.
Thank you.
Absolutely. And okay, well, With that, I would like to turn to our final presentation and talk that we have today from our excellent Professor Stephen Freeland, who I'm also honored to work with very closely. He is the Vice Chair of the Working Group on the Legal Aspects of Space Resource Activities, and along with our Chair, Ambassador Andrei Mishtal. And Stephen, it is of course such a pleasure to have you here with us and to share some words, especially on this topic of Article 2. We're going to go back a little bit to Article 2 on the notion, and this is where we were talking about these lines being drawn. Where are the limits of what do we consider national appropriation? What do we consider? How far can one go? This is, of course, like I said, the favorite topic of all of us lawyers. You know, what is it that we can do? You know, how far? What's the worst that can happen? Is our favorite game, basically, that we like. Without further ado, let me go ahead. Would you like me to share your slides for your talk?
Mike, hi. Firstly, you can hear me?
Yes, we can. Thank you so much.
You're doing such a great job sharing slides. I don't want to break the sequence, so that'd be great. Thank you.
See what I can do for you. Let's see. Oh goodness.
You've lost them?
Yeah, I have not lost them. Just bear with me just one moment. It seems that it's logged me out. Okay.
That's okay. I'll just talk, and then when you get the slides up, that'd be great.
Okay. Please do so.
Yeah, thank you. Thank you so much, Mike, for the lovely warm welcome and for inviting me to participate. It's just an honor for me to be here and an honor to share the floor with my amazing friends and colleagues, yourself, of course, Olavo, Andre, Gabriel, and Tare. It's a real privilege. And I also want to thank Gabriel and Tare for their flexibility. I was, as the original program said, supposed to be speaking earlier, but I'm here in Dubai at the Dubai Future Forum, and I was required to be in two places at once. And of course, that's not possible. So thank you, Tare. Thank you, Gabriel, for agreeing to shift around. But that explains why we're going back to Article 2, having heard that wonderful presentation on Article 3. While Mike is getting up the slides, let me also say I'm here in Dubai at an amazing event called the Dubai Future Forum, which is looking at the future. And there's a whole range of people from all sorts of disciplines talking about life on Earth and life elsewhere, and how humanity will cope in the future. And I find it really interesting that as we're talking now about a fundamental treaty, thanks, Mike, a fundamental treaty that, as we all know, was finalized and came into force 56 years ago. Some people have said, well, you know, this is so old, it can't possibly be relevant to where we are. But this treaty and the fundamental principles that we're looking at have served us extraordinarily well in those 56 years, notwithstanding all the challenges, continue to serve us well, and will serve us well in the future. These fundamental principles, in my opinion, and I'm sure that's an opinion that's shared by many of my colleagues, are more important now than they've ever been, given the complexities of space, given the diversity of actors, given the diversity of activities, and given the incredible and critical elements that space plays in every society, every community, every country. So I congratulate you, Mike. You've done an incredible job to put this conference together. I also incredibly think it's incredible that you focused on this treaty And I urge everybody to listen as much as you're able to, wherever you are in the world, to all of the presentations, because, and this is a fundamental point that I'll be making during my presentation, even though each speaker is looking in a sense at separate articles slightly in a siloed fashion, and I'm doing the same, the message that's already come through, and I was able to listen to some of the presentations, even though I'm in another conference, the message that's come through is, of course, the Outer Space Treaty, international law more generally, the other treaties, you know, they represent a holistic approach to the regulation of space. And so it is sometimes too simplistic and a bit inaccurate to look at one particular provision in isolation. I will do that, but I will then make the point when I pose some questions. So, Mike, you were talking to Tare just then about being disappointed that questions about lines have not been answered. Well, you will be totally dissatisfied by this presentation. You gave me the rather provocative title, What Could Cross the Line? And these are really complex issues. So what I propose to do, obviously, is to examine Article 2. We need to understand what it is we're talking about before we can even begin to work out what might fit on one side of this imaginary line and what might fit in the other. And then I propose really to give a whole range of examples. I don't pretend to have the answers, but hopefully it'll be a bit thought-provoking for everybody as to where you might think on this imaginary line certain activities might have. So with that, Mike, if you could kindly go to the first slide. Thank you. So the non-appropriation principle, we've heard some references previously to it. For me, it is the fundamental of fundamental principles in the Outer Space Treaty for many, many reasons, and I'll elaborate on that in a moment. Of course, it's reflected in Article 2 of the Outer Space Treaty, but the important point, and this is not unique to the non-appropriation principle, but it's important to note this, that this idea of space being different, space being an area that is not capable of appropriation, was well established almost from the get-go in terms of humans' ability to go to space in a meaningful way. That is, shortly after Sputnik. And as some of you will know, I am a Sputnik baby. I was born in 1957. And so it's important for me to ensure that you get this issue that really from the very beginning, it was understood and then encapsulated that space was different in this way. And so if I can refer you on the screen, you'll see, and these resolutions were referred to in no doubt in previous presentations in 1961 and then 1963, this notion was already well established. It's interesting, though, if you compare the wording in Resolution 1721, where non-appropriation, i.e. that outer space and celestial bodies are not subject to national appropriation, is then expanded in Resolution 1962 of 1963, where it refers to national appropriation, but then extends to those words that themselves are encapsulated in Article 2, which is in red. I think somebody would have referred to it previously, but outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. One interesting point, although this is a side issue, but if you notice the difference between the two resolutions and Article 2, the two resolutions, in a sense, differentiated between outer space and celestial bodies. You can see in both of them they said use the plural. And that gave rise to some interesting discussions. And for clarity, Article 2 makes it clear that the moon and other celestial bodies are part of outer space. They are not a separate notion, which you could have read in the way the resolutions are set up. And that's important because, of course, as we know, the Outer Space Treaty talks about outer space. And so we're clear that outer space is not only, if you like, the void of space, but also the celestial bodies. It's a small point, but it's an important point to note. I would also refer you, being from Australia, my country is a states party to the Moon Agreement, and the non-appropriation principle, in almost identical terms, is also incorporated in Article 11.2 of the Moon Agreement. So, point number one, this is something that was well understood really from the beginning. And so my next slide, Mike, if you could pass, is why? Why do we have this principle? Because I think the rationale, I always think, to understand what provisions mean, what the law says, one has to understand the context and the reasons behind it. We have to work from first principles. And so let me, if I can, for a couple of minutes, give you some rationale as to why we have this principle. And these are in no particular order. But firstly, it's a logical extension from Sputnik. What do I mean by that? Okay, with leading up to Sputnik, the Sputnik successful mission by the Soviet Union in 1957, there were discussions, for example, theoretical discussions about what was the extent of a country's sovereignty above its territory. Well and truly understood by then, already from 1919, but well and truly understood that, of course, the airspace of a country was within its national sovereignty. It's almost like territory. It's not quite. There are some slight wrinkles, but essentially, that it's recognised that countries have exclusive and permanent sovereignty over their airspace. However, some postulated that because we didn't understand where space was, or if there was something different, that sovereignty extended without limit. Along comes Sputnik. No doubt, Sputnik goes to altitude. It had an elliptical orbit, but it goes to several hundred kilometres above the Earth, starts overflying countries, and it's clear from the lack of protest, it's the lack of statements of saying, you need my permission, etc. It's clear that wherever Sputnik is, it's not, in a sense, violating the sovereignty of the countries over which it's flying. And so quite quickly we understood, and indeed we've had reference to customary international law. We all know customary international law is very difficult to prove, but there is some jurisprudence from Judge Manfred Lacks that said, in this case, there was almost instantaneous customary law, that there is something above airspace, which we will call outer space, which is beyond national jurisdiction. And so if something is beyond national jurisdiction, national law does not apply. So I'm currently in the UAE. The UAE national law applies to UAE airspace, but it doesn't apply to the outer space above here. Although under registration, it might apply to UAE satellites and personnel. We understand that, but not to the area. And so if you have an area that is beyond national jurisdiction, an extension of that idea is that, well, it's a non-territorial area. Although we have to make it clear that you can't then claim it to be a non-territorial area. But the idea that we have non-appropriation leads logically from the legal status of space. In addition, and we've heard, I wasn't able to listen, but there were presentations by my dear friend Olavo and Andre about Article 1. The notion that there's a non-appropriation principle, and I'll go through each word in the treaty in a minute, but the notion that it's not subject to claims of sovereignty, for example, are again a logical extension and follow from the fundamental principles that are encapsulated in Article 1. That is, space activity should be for the benefit and the interests of all countries. Note also that in the preamble to the Outer Space Treaty, it doesn't say countries, it's peoples, which is in a sense even broader. That the exploration and use of outer space is the province of all humankind, which most people think means that essentially everybody has the freedom, the right to the possibility to explore and use space, obviously subject to whatever restrictions there are in the law. The notion that all areas of celestial bodies have free access. Remember, celestial bodies are part of outer space. The notion that there's a freedom of scientific investigation in outer space. All of those notions encapsulated in Article 1 lead to this idea that you can't claim an area for a particular country. Thirdly, and this is more a policy reason, but if you look at the history of warfare on Earth, sadly, humans have been at war with each other almost since the time we were on the planet in significant numbers. And a large proportion of those conflicts have been about territorial claims, and the idea of seeking resources. And so early on, it was understood that non-appropriation as an idea, as a concept, as a principle, particularly in the context of when Sputnik happened, when these treaties were negotiated in the context of that tense geopolitical time, it was clear that everybody understood that it's important to have this to, if you like, lessen the possibility that we're going to have conflict in space. If you put aside any possibility that you can claim territory, if you put that aside, then in a sense, and you know, I call it a conflict avoidance mechanism, you know, as opposed to a dispute avoidance mechanism. But in the context and the history of where we were at that time, it makes perfect sense. Even more so, and again, this is slightly cheeky of me, but history shows us that in the early 1960s, as we're all aware, there was this so-called space race, obviously between the two main space powers of the time, the United States and the former Soviet Union. And one of the important aspects of that, particularly after the famous speech of President Kennedy at Rice University, was to get to the moon, to get humans to the moon. And if one looks at the historical archives in the early 1960s, that was clearly an important part of the space programs of both of those countries. It was not clear at all who was going to get there first. In the context of, and you know, people call it a race. You know, you may not agree with that as a nomenclature, but that's what many people talk about. And there was clearly this idea that both of them thinking, we need to get to the moon first. That's a major, significant achievement. And it was not clear who was going to get there first. So from a pragmatic viewpoint, the two major space powers, and clearly supported by the rest of the international community, agreed that, well, I don't know whether you're going to get there first, you don't know whether I'm going to get there first, so let's agree that we can't claim it for ourselves. It's not something as a territorial claim. So all of those contextual, legal, and political frameworks, I think, help us to understand why we have it. It is so important. You know, for me, that idea of the conflict avoidance mechanism is so important, but all of these ideas are important. And it made it clear to me, and hopefully many of you agree, that space is different. It was regarded as different then. This is important. Remember, we already had, for example, the Antarctic Treaty of 1959, but that was on a different basis, where you already had these claims of sovereignty, which were under the terms of the treaty held in abeyance, but they still exist. And they were not, it's just that states could not act on them. But space was regarded as different for a whole range of reasons. And so the non-appropriation principle is there for real valid reasons that were valid then, valid now, and will clearly be valid in the future. Next slide. Thank you, Mike. So let's quickly go through the elements. And I think a fundamental thing, again, I'm stating the obvious, forgive me, but I think it's important that sometimes the obvious is stated. The wording, it says that outer space is not subject to. That means, it doesn't mean it doesn't mean you can't do it. Well, it does mean you can't do it, but it means no matter what you do, it just is not an issue for space. No action can ever sustain a claim of appropriation. It is not subject. It's just not on an issue for space. That's what the provision says. It talks about then the ways, you can't claim it through national appropriation, through use or occupation, through any other means. So let me quickly go through that. You can't claim national appropriation through those means. What's national appropriation? Well, again, I don't want to be too technical here, but the main issue, we all understand that it's agreed that countries can't claim, but many say, well, at least in the relatively early days, well, it binds countries, but in private entities can claim. And some of you will be aware of some companies that have purported to say they own the moon, they own Mars, whatever. For a whole range of reasons, that has no legal basis. And so this non-appropriation principle extends and applies not only to any quote-unquote purported act of appropriation by a state, but it also prohibits any claim by a private entity for a whole range of reasons. I can go through that in more detail, but I think that really is something that most of us now understand. So national appropriation, the fact that it's national doesn't exclude non-governmental entities. We just heard of, for example, about in another context, Article 6, talking about national activities, and it's clear that national activities include non-governmental acts of non-governmental entities, the way that Article 6 is framed. And so national appropriation means appropriation either by a state or purportedly by a private entity. There are property rights that are not excluded by this. For example, the whole notion of intellectual property rights. Now, again, that's a whole topic for a whole other debate, Mike, but and intellectual property rights, which is a form of property right, if you like, will become more and more relevant in space, and we can talk about that. Okay, so we know what national appropriation is. Claim of sovereignty, pretty clear, right? This protects, for all the reasons I've said, any claim that states, in a sense, sometimes we hear about people talking about colonizing space, etc., etc. We've got a long and sometimes very tragic history on Earth of colonization of territory. We can't do that in space. So there is no claim of sovereignty. It's pretty straightforward. Then we have use or occupation. I know that Gabriel was going to talk about occupation. I wasn't able to hear it, although I'm sure he was very lucid in it. Gabriel's wonderfully adept at explaining these things. For me, use or occupation, they're two separate concepts. Use, obviously, you flow it back to Article 1, which begins about the exploration and use. Use is a broad term. Use applies to the freedom principle. You can do you can use space in any way subject to whatever limitations exist under law, including under the treaty. So, but assuming you're doing a lawful use, whatever you do will never constitute an appropriation because space is incapable of being appropriated. Occupation, from my perspective, occupation, and remember, this is 1967 when some of these terrestrial international law principles were being developed. Occupation is a public international law, is a way terrestrially that states have managed to acquire territory on Earth. There are notions of occupying something that is, in a sense, discovering and then occupying, this notion of terra nullius, although that's been transformed a bit and it's very controversial. There's other case law about whether a state can claim to have acquired territory through what is called a continuous and peaceful effective control. That's an occupation. So public international law, general international law, recognizes occupation as a mode of states acquiring territory, just doesn't apply in space, no matter what you do. And then, for the avoidance of any doubt, if you still think, well, there are still loopholes, right? There are not, because we then have this incredibly broad catch-all phrase or any other means. So it's absolutely clear that non-appropriation applies, and there's absolutely nothing you can do that would lawfully allow an act of appropriation. I think that's clear. I hope this hasn't been stating the obvious, but I think it's important to understand that, because Mike has very cheekily asked me to say, well, where are the lines drawn? So let's move to the next slide. Okay, so this is it. But this is where I ask the questions, but I'm not going to give the answers. But with everything that I've said, the underlying understanding that from the get-go, we all agreed this was important. The underlying rationale for it, the absolute comprehensiveness of the words, okay? Hopefully we all now understand, I'm sure you did before, but hopefully we now have a clear idea that this really means something. So I'm going to just quickly walk through a whole range of different scenarios, and I'll leave it to you to decide for yourself. Is this an purported appropriation and therefore in violation of this idea that of what Article 2 stands for? And here I make the point that I made before. I've been talking just about the one provision, looking in silos. But to answer this question, one has to look at the entirety of the treaty, because other really important principles will also be relevant to these questions. And indeed, other areas of international space law and other areas of international law. So the answer to these questions is not necessarily just in Article 2 or limited to Article 2. Okay. So, and this is in no particular order. I drafted these examples late at night with a glass of red wine in front of me, so it just came to me. So the first one, a claim to a segment of the geostationary orbit above a state's territory. We are aware, for example, historically, of that this was in fact the case. The 1976 Bogota Declaration, the equatorial states, I can't remember, were there 8 of them, or I can't remember the exact number, I should know that, made a statement that because we don't know where that boundary is between airspace and outer space, and because of a whole range of reasons, there were claims made that the segment of the geostationary orbit above the equatorial state, given that the geo is an equatorial orbit, were part of the state's territory. And indeed, in 1 or 2 countries, that was then encapsulated in their constitution. It's pretty clear, and it's pretty clear that that was not accepted as being a legally acceptable proposition. Is it a claim of appropriation or not? I'm not sure, but it's probably clear to all of us that that's not a proposition that is accepted under international law. Some states might still believe it to be the case, but it's not. What about placing a flag and claiming it for that particular state? Of course, we have examples of countries placing flags on the moon, but no country has placed a flag and said, I claim this for my country. Yeah. In the sense that terrestrially, under occupation and perhaps terra nullius, that has been done. No country has done that. Those that have placed flags on the moon, for example, have done that, but made it clear they are not claiming it. But of course, they're saying we got there, and this is part of what we've achieved. So, if a country were to do this, would that be an appropriation? Probably. Most people would say that you just cannot claim, and for the reasons I've said, I think that's pretty clear. What about claiming part of space, the property rights of a part of space, or in fact the entirety? As I said, some people have claimed the moon, some people might claim other celestial bodies, for example. If there is this line, Mike, that's probably on the wrong side of the line as well. Again, I don't want to be definitive here. People might have different views. What about this one? Declaring an exclusion zone. So I'm not saying safety zone, let's put that aside. I'm saying exclusion zone. Saying, for example, in orbit, I've got a valuable asset, it's key to my critical infrastructure. I'm saying to the world, this is a country, I'm saying to the world, keep away from my satellite, X kilometers away. I declare this exclusion zone. Or I'm on a celestial body, keep away, it's an exclusion zone. Is that an area of appropriation, an act of appropriation? Well, it may or may not be an act of appropriation, but clearly it's also in breach of other principles. For example, this notion of freedom of access, which is why I think it's important that, we don't answer this question just looking at Article 2. Article 2 is our starting point, but there are many other things as well. What about collecting and removing samples of the natural resources of the celestial body? We know that, of course, humans have done that. States have done that. There have been, in a sense, absolutely no complaints by anybody that I'm aware, and Mike, you might know, but I'm not aware of any complaints by any country about samples that have been taken by the Apollo missions and by subsequent missions, by the rovers, etc. So that's probably on the right side of the line. Yeah, it's the sample taking. And indeed, there are many missions to go to the moon that will exactly do that. I stop here to say also, if you're a state party to the moon agreement expressly allows this. So for those 18 states parties, currently 18 states parties to the moon agreement, if somebody challenged them to do that, they also have this express right in that treaty that they would hold on to as well. What about the next one? Using natural resources to support a scientific mission. Again, there's a lot of work being done on that. Again, the moon agreement expressly permits the states parties to do that. Again, it's only a small number of countries, but for those countries at least, they could say that they have an express right under the treaty. For other countries, of course, they can't rely on the moon agreement if they were to do this, but they might find some other ways. One would probably hazard a guess to say that's on the right side of the line. Supporting a scientific mission. Now we're moving into things that perhaps because I have a role on the working group on space resources, I'll certainly not give a view on this, but of course there's a lot of discussion about the exploitation of space resources for commercial uses. Again, the moon agreement talks about sample taking, it talks about supporting a scientific mission, and then it says perhaps in the future there might be exploitation. So at least under the moon agreement, those two other things are not exploitation. This is something if you like, more of a greater degree. Is the exploitation of space resources for commercial purposes an appropriation? Of course, that's part of the discussion about the whole notion of space resources. There's been a lot said about that. There are a lot of views. I won't express my own personal view, except to say that there seems to be an assumption, given that we are now moving on to looking at the principles that may support future space resource activities. Seems to be assumption that in particular circumstances, this is a permissible activity. Again, I don't express a view because it's not my role to express a view. And as part of the working group on space resources, one of the things is to try to work out what the current law says. What about, though, if you exploited that celestial body, say it's a small asteroid, essentially to the point where it no longer exists? That is a separate idea. Again, I don't express a view on this, but you may or may not believe that it is a different situation, again, from the one immediately above it. There was a celestial body. It's part of outer space. You can't appropriate it. You use that celestial body and it no longer exists. I'll leave that one with everybody. There's a lot of discussion now about orbits and I'm not sure what that's an appropriate word, but there is, and we're all aware of the discussions about particularly low Earth orbit and the increasing number of satellites, in particular, quote unquote, popular orbits. And some have argued that at some point there will be, the excess number of satellites for an orbit to be usable in an appropriate way. So if, for example, Stephen Freeland Enterprises were to put, 20,000 satellites in one orbit, all of a sudden, would that, in a sense, be an appropriation by the country that, under whose jurisdiction I am under? Because arguably, I'm not a scientist, but let's argue for the sake of this, that would mean that Mike Newman is essentially unable to utilize that orbit because there are too many satellites. Okay, is that an appropriation? What about this last one? Countries purporting under their national law to grant ownership rights and property rights to the natural resources. We know from the conversations that are going on in natural resources, quite a number of countries have done that already in different ways. And so, of course, people have different views on that. It is interesting that at least in some of those countries where under the national law, and of course countries can pass any national law they want as long as it's constitutional within their own country. But in some countries that have passed that sort of law, they say, they purport to give these rights, but it always says subject to our international obligations. So in a sense, it's circular and goes back to the international law. And there may be other examples. So, Mike, I really haven't answered the mandate you've given me, but hopefully this gives food for thought. My final reflections on this are the following. As I said, this is a fundamental principle, the non-appropriation principle. We need to adhere to it to avoid... No, you don't need to put the slides back up, except for me to say thank you. We need to adhere to this principle for a whole range of reasons, not the least that it, in a sense, lessens the possibility of there being conflict and disputes. This is a fundamental principle. The danger is that we begin to think of it in different ways. The danger is that, in a sense, we forget about the historical context. We forget about the underlying reasons. It wasn't put in there in 1961 to deal with space resource exploitation. It was there for a lot of broader reasons. Clearly, it's relevant to current discussions about space resources, but it's got a much, much broader heritage. And that's crucial that's crucial to us all in terms of the maintenance of peaceful activities in space. And so I've been privileged to talk about what I think is just an unbelievably important principle. I hope, Mike, even though I haven't answered your mandate, that at least I've done part of a job and raised some questions, and I'd be very happy to take anyone's questions or questions from you, Mike. Thank you for giving me the opportunity to speak, and over to you.
Thank you, Stephen. It is such a pleasure to hear your views on this. I mean, and of course, I knew that I was never going to pin you down to anything in particular, and it's exactly this that is the challenge that we face, is coming to grips with what this term means in the context of our future space activities. How do we square these activities with this provision that we've all bound ourselves to if you're party to the Outer Space Treaty? And one of the things that I reflect on, I was looking very much through the Tratado of this and of the Declaration, and this permeates, just like you had mentioned, this permeates from the very core, from the very beginning of what this new endeavor was, the implications of the new endeavor. And the implication is, of course, this is, again, this next march of humanity, and what to do about the problems that accompanied humanity in its march across planet Earth. And so we have the same thing that we're trying to come to grips with now. And we know in a way that there will be, of course, the utilization of space resources for the conduct of missions. There's just no way, and this was brought up into the chat a bit ago, was to what extent the utilization of space resources is necessary for activities in outer space and the sustainment, say, of missions, of human presence. And it's clear from all commentators and all observers that we're not going to take everything with us in order to survive. I mean, no, that's never been done. We'll always have to live off the land somehow. And so in a way, every state that has an interest in doing the activities has an interest in finding a way to utilize space resources first, to then find a way that encourages others to play their own parts in it, whether those be commercial parts or whether those be various state parts. How do we determine that such activities have benefits for others? What do we think about public utilities when it comes to this, or rights of those in need, potentially of survival, of life support requirements? How do we come to grips with all of those things as humanitarian efforts that we've seen troubling us on Earth? How are we going to deal with those in space and in space resources? And these are exactly the topics of this working group on the legal aspects of space resources. What do we do about these priority rights? What do we do about information sharing? What do we do about sharing of scientific results of all of this? And where this notion of appropriation, and where does it cross the line? It crosses the line when states want it to, whatever it is. And this is what Terry was alluding to as well. And this is what we always are faced with in international law, it seems, is that and rightly pointed out by Manfred Lachs with Sputnik, it's immediate. If no one objects, it's immediately acceptable. And the question is, how do we make sure that we do things in a way that's acceptable to others, that's acceptable to the states that don't have an interest? One of the things about the Outer Space Treaty, of course, was how do we make these basic principles so that space activities are lawful. And one of those ways was to protect the interests of those that have no interest in those space activities at all. That's why this absolute liability for injury and damage caused on the ground, especially under the the Liability Convention, is so important. It's a victim-oriented mechanism that protects those that have no interest in carrying out this activity. So in the same way, we have to find a way that we can look at space resource activities and space exploration activities that it takes into account all the needs of those states that don't have necessarily a say in it or a part to play in it, but they are accounted for under the Outer Space Treaty, just like Professor Bittencourt had made very clear, is that those interests of all states have to be taken into account. And so, yes, of course, I always want to see where the line is drawn. But of course, I know that it is drawn where states want it to be drawn, obviously. And that coming, yes. And I would say that we are lucky in a lot of ways. And I'll leave this, and I'll come to some questions in the chat. But you know, when looking at our work in the legal subcommittee and the work of the international community and coming to consensus, these were the troubles of coming to consensus in the early days of under Manfred Lachs, and then as successive people have carried the torch for the chair of the legal subcommittee, that difficulty, that burden of achieving consensus on difficult issues, we see it continuously. We see it happening, and we see it playing out now. We saw the difficulty of coming to consensus in our working group in this last legal subcommittee session. But that no consensus has happened before, but it has not stopped the progress or the conversation or being able to arrive at it again upon reflection, upon enough time, enough views being expressed, and then to come to a way that we can all see a way forward. And I think that's what we're going to see, of course, with our working group on the legal aspects of space resource activities. And so maybe if I turn to maybe the chat to see if we see some questions that's maybe you can talk about this. This always comes up, and this is also the crux of many issues that come with the Artemis Accords. This notion of the safety zones, this notion of exclusionary zones. This is brought up into the chat. Is this type of way that you say, okay, because we look at this maybe from a common law perspective of the bundle of sticks and your rights in property and your rights to exclude others from, it's probably the most powerful of all property rights there are. Is this tantamount to this appropriation idea? What are your thoughts on how the progress has been made under this multilateral, this activity of making this Artemis Accords versus other multilateral activities, say under the International Research Station of the Chinese and the Russians? Like, how is the interest of all of these countries similar enough that we can understand what this notion of safety zones is as an implementation of what even Gabriel said before? What are your thoughts on that?
Oh, wow. Great questions, and thank you for those in the chat as well for your comments. I'm sorry we won't be able to get to all of them because I will have to go back to my conference. But on the safety zone, so you'll note in my presentation I talked about, you know, something much different from the notion of safety zone as I understand it, as expressed in the Hague Working Group, and then as expressed in Article, I think it's 10 of the Artemis Accords, or I was talking about exclusion zones. And I hope everybody understands that that's what I'm talking about. If I say, Mike, you cannot come here, and if you do, I'll take action, right? That is clearly an exclusion zone. That is, as I understand it, not what is being proposed by some of these ideas. And as I've said always publicly, you know, as we move forward to try to work out these initial principles under the mandate of our working group, we're not starting with a clean slate. We have many incredible people have thought about this for a long time. And so we have lots of incredibly important inputs, both under law. So I've mentioned the Moon Agreement and some of the ideas there. We've got the Artemis Accords, we've got the ISRU, if some documents become public, we've got the Hague Working Group, we've got so many inputs already. Plus, we're going to hear from some experts at conferences next year. So all of those things will be part of, somehow feed into the multilateral discussion. My point is this, I am honoured to be part of this multilateral process, but I also believe in it. I believe in it for the following reason. Remember, going back to that fundamental notion of why we have non-appropriation, to stop conflict. For me, Mike, if you and I want to do the same thing in a relatively close geographic area, in incredibly hazardous circumstances, and if you are operating under one set of rules, and if I am operating under another set of rules, they might be similar, but they're not identical. There's a greater chance that you and I will have some misunderstandings, miscalculations, etc. So we want to, this is now a personal opinion, of course, we want to avoid that, to have a common set of understandings. Even if you and I don't cooperate, we don't work together, but if we have a common set of understandings that we both operate under, I think that's, minimizes risk. But more than that, and this is why multilateralism is so important, of course, there are people that are frustrated with the UN process. There are people that are frustrated with COPOS. On the other hand, and you mentioned countries that will never essentially be able to exploit these resources if indeed those activities go ahead. But they have a voice. Everybody has a voice. We all have a stake. Space touches every person in the world. Space is critical to every country in the world in different ways, but it's critical. And so the beauty of this multilateral process, as sometimes convoluted as it is, and you and I, Mike and Andre, would love to have solutions tomorrow, but we know it's a tough road to hoe, but we'll get there. The beauty of this is that it's a process where every voice that's relevant, I'm now talking countries, of course, we want to hear from others as well, but in the end, the decisions, at least at the UN, are made by countries, but where every one of those countries has the opportunity to contribute. And so that you and I, Mike, even if we don't like each other, even if we don't cooperate, we are more likely to adhere to a set of rules that both you and I have had input into and had the opportunity, rather than me foistering rules on you. Right? So 2 elements. We need a common set of rules, but we need a common set of rules that we've all had the opportunity to contribute. The rules themselves, are important, but I think the process is equally important, which is why multilateralism is so important. That said, nothing is perfect. Nothing is perfect. But my mantra always is with this, we have to maximize the benefits and minimize the risks. For me, the biggest risk is one of conflict. That would be a disaster for humanity, a disaster for humanity. And so to avoid that, we have to find commonality. You mentioned, and Tare mentioned about shared interests, common interests. There is a common interest to do this, even if you and I are never going to work together. We have a common interest because we both want to get on with it. And so we don't want to be spending our time worrying about what rules you're operating under, et cetera, et cetera. So, I hold out hope, but we have a long road to hoe. But for me, in these big issues of space, and this is a big issue in space, along with other things like space debris and space traffic management, but this is a big issue. This multilateral process is the way, but we have incredible inputs to feed into that process already. So we're not starting with a blank sheet. We've got incredible ideas thought out by incredibly articulate, intelligent people who have expertise. And so that's helpful. But in the end, I don't want to be an apologist for the UN process, but I am in this case convinced that that is the way we're going to maximize benefits, minimize risks when it comes to something like this, if it ever happens, because this has inherent risks already of a technical nature, of an environmental nature, of, and clearly of a strategic geopolitical nature. And so we've got to just do our best. So that's all I can say about it, Mike. Obviously, both Andre and I are really in the hands of member states, but we believe that member states understand that. They will fight to have the rules that they want, of course, but they will understand in the end that we have to find a common way. And so I am cautiously optimistic. Otherwise, I mean, you're the same. Otherwise, we wouldn't do what we do, right? So I hope that answers all of those ideas. And Mike, I'd better get moving in a sec, but I'm sorry about that. Yeah.
No, absolutely. Stephen, thank you again for sharing your time, for sharing your views. I really appreciate it. And I fully agree. And we, of course, we continue the endeavor. And I know you have many things, and I really want to thank all of you, all the presenters. Stephen, thank you so much for spending so much time. We've run over quite a lot of time, but it's so valuable for everyone. And I will endeavor to even try to find a way to answer some of these in the chat, even if I open up a little bit early tomorrow, maybe, or even stay over tomorrow. I will look more through this and see what I can do. Thank you again, Stephen. And maybe yes, and I can give a few words of wrap up for today's proceedings.
Thank you, Mike. I'll go. Thank you, everybody, for staying out to the end. And Mike, thank you again for the invitation.
Really appreciate it. Thank you, Stephen.
Bye-bye.
Yes, dear participants, it's been an amazing day. Very fruitful discussions I think we've had. We've seen, and in a way, I wanted to track the very beginning of our space endeavors from the very beginning, from the principles and ideas that were there at the very start. I think that they're relevant today for our consideration. And we've heard lots of different views about how we think about outer space, how we have thought about it in the past, and what are new activities, especially when it comes to, especially in the space resource context, which is what was covered a lot today. Tomorrow, we will be discussing even more about international responsibility for activities in outer space. We will be discussing also unique parts of the Outer Space Treaty that have been impacted, including, the understanding of what phenomena are dangerous phenomena under Article 5. We will also hear about this notion of security and trying to come to grips with ensuring that space is used for exclusively and only for peaceful purposes. And we will see what that means in this context of ongoing activities in the disarmament field and how that will impact us in how we will engage in future space activities. And we will look at how orbital activities are in a way much more different in concept and much more present in what we are facing now. Like what we will have to come to grips with will be orbital activities. It will have to be an understanding of, and this was brought up even by Gabe in his work in the Department of Commerce, with space situational awareness, coming to grips with the data that is out there, understanding the reality of our situation, the reality of more and more space activities, this increase in orbital activities of all kinds. And so it's very it's with my distinct pleasure that I'm able to have this conference and be able to organize this. It truly is a product of our times to be able to bring this many people together. I really am very honored to be able to do this for the United Nations, for all of you dear participants. And with that, I would like to invite you tomorrow again. I will put the login information on the website of the Office for Outer Space Affairs on the page for the for the conference, for your ease of access. I know that there might be difficulties with this. I want to be able to facilitate that as much as I can. I want your participation. I tried to look in the chat as much as possible. Even with my difficulties, we will take everything into account. And I really appreciate your participation again. Thank you so much. And with that, I would like to close today's proceedings and wish you all a very fine rest of your afternoon or morning or evening, wherever you are. Thank you.